Hey, good morning, everyone. Thank you so much for skipping or sacrificing the break time for us, just in the spirit of staying on time and not delaying your day further. So welcome all to the second panel discussion today in SCCA Symposium. My name is Fatimah Balfaqeeh. I'm the SCCA's Dubai director. Today we're going to discuss to evaluate the ADR friendliness of state, the relative competitiveness of ADR institutions, and the appeal of legal seats for arbitration in the GCC. Today, my panelists need no introductions. They're all superstars in their own right. But we'll attempt to introduce them. We'll start with Richard, who's a partner at Clyde & Co. and specialist in commercial dispute resolution. He has 15 years experience dealing with cases in Saudi Arabia, both in arbitration and before the local courts. Richard's primary area of expertise is assisting multinational clients to resolve disputes with local counterparties, and his clients include trade credit banks and Fortune 500 companies and regional conglomerates. Then we have Amani Khalifa. Amani is a counsel in Freshfields and a global project dispute practice and an arbitration specialist. She handles large complex construction disputes relating to projects throughout the MENA region. Amani have been named, of course, as a leader of arbitration by Who's Who Legal, and she's currently a judge in the Bahraini Court of Cassation seconded to the BCDR. She is also an arbitrator on the Basketball Arbitral Tribunal and an independent arbitral recognized by FIBA, an anti-corruption hearing officer in the Tennis Integrity Unit. Then we have Paul Stothard. I'm sorry if I butchered the last name. Is a dispute resolution lawyer based in Dubai. He has particular experience of international arbitration and advises clients on international disputes involving construction, energy and infrastructure, financial institutes, international trade, retail, hospitality, and so on. Paul has experience in both commercial and investment disputes and have acted for both investors and states. He also appears as an advocate and have been appointed as an arbitrator on numerous occasions in different seats as well, London, Tokyo, Beijing, and Dubai. Then we have Cameron Cuffe. He's the head of Middle East dispute resolution at Ashurst LLP and specializes in international arbitration with a focus on energy, infrastructure, and construction-related disputes. Cameron has acted as counsel in numerous domestic and international arbitration under the ICC, LCIA, DIAC arbitration rules, in addition to the UNICITRAL ad hoc arbitration. He also advises clients in relations to expert determination, dispute adjudication boards, adjudication and mediation. Cameron cases have included complex energy, engineering, and construction-related issues. And last but certainly not least, we have Thomas. Tom is a managing partner at SBP UAE offices and heads its construction and arbitration practices in the MENA region. He serves as a lead advocate in arbitration proceeding of all types, based in the UAE since 2008, so practically a local at this point. Tom is among the leading construction lawyers in the Middle East. He has 26 years experience resolving disputes over construction and operations of infrastructure assets. Tom also serves as project counsel on major projects. So welcome to all my panelists, and we're going to start with ladies first because as the belle of the ball, she has to leave very shortly.
Thank you, Fatimah. I really appreciate that. I hope everyone can hear me. It's a pleasure to be sharing this panel with you, and congratulations on your appointment.
Thank you very much, Amani. First question goes to you. How are changes in the substantive legal landscape likely to impact parties to complex disputes in Saudi Arabia?
Thank you, Fatimah. Well, I don't have a lot of time, so I'm just going to focus on two very, very important changes to the Saudi legal landscape that I personally am very, very excited about, and my team and I have been looking at closely. The first is a document that's been in public consultation, and that is the Commercial Transactions Law. And for the construction lawyers out there, you will be familiar that it applies to construction contracts. And that potentially introduces some very, very significant and important changes, including the recovery of lost profits, which will change, I think, how contractors actually price their bids and increase certainty on how the law is actually going to apply to those contracts. The second, and perhaps even more significant piece of legislation, is the draft Civil Transactions Law. There are documents floating around on the internet that claiming to be the draft Civil Transactions Law, but it hasn't been put into public consultation. We know it was approved by the Shura Council on the 7th of May. Thank you. And two very exciting developments that I've seen from the documents claiming to be the Civil Transactions Law. The first is in relation to liquidated damages. And I think it's fair to say it's a much more modern approach than we've been able to glean from the cases in Saudi at the moment. So recover LDs, they're exaggerated, or unless there's been no loss, that's potentially very, very significant for employers under construction contracts as well. And the third and final major change relates to prescription periods. So it's 5 years under the draft Commercial Transactions Law and 10 years under the Civil Code. So I think those are just three highlights from two very, very important pieces of legislation. Taking a step back, that will really make construction companies' pricing work in the kingdom much more competitive. They're pricing in a lot of risk at the moment, and I think those major changes to the law will increase competitiveness and certainly help us advise our clients. As an Egyptian lawyer familiar with the Sanhuri Civil Code, I think it's a bit of a relief to me personally that I won't be trawling through the Ministry of Justice website to find those cases. So very, very welcome indeed.
Thank you very much, Amani. And indeed, there is, alongside with the encouragement to use ADR in general, it's really important that we see that there is a huge legislative development as well in Saudi Arabia that only fortifies and enforces the position that Saudi Arabia as a government have adopted that is absolutely in line to the 2030 vision. Richard, if we take a step back as well to, if you can provide us with an update on recent development in Saudi Arabia in relation to mediation, another aspect of ADR that is very important to SCCA and Saudi in general.
Yes, I agree with that statement. For those of you who aren't familiar with the process, mediation is a form of structured negotiation where the parties engage a neutral mediator to help them overcome roadblocks to a negotiated resolution of their dispute. It's very popular in the common law world. It perhaps hasn't been used as widely in the Middle East, but I think that is starting to change now, and it certainly is starting to change in Saudi Arabia. And just some highlights as to how that is happening. First of all, the SCCA itself, our host, has a mediation centre which has its own rules, which are in line with the mediation rules and services of, the more well-known international arbitration centres. It's very good. It has a very distinguished panel of mediators, so parties can use that service to resolve their dispute before they go to arbitration or litigation. So that is a very positive step. Secondly, the SCCA is working in tandem with the courts in Saudi Arabia. The commercial courts have an arrangement pursuant to which smaller claims of a million SAR or less can be referred by the judge to the SCCA Mediation Centre, where they can be resolved, and where a resolution is reached, that can be codified in the form of a judgment which is enforceable by the parties. Finally, mediation, after a fashion, is being used by the courts to resolve disputes as to costs in litigation. So, unlike in other parts of the GCC, in Saudi Arabia, a successful litigant can make an application to the court to recover their costs, and in some cases the court is referring that portion of the dispute to mediation in an effort to get the parties to agree on an appropriate costs award, which again can be enshrined in an enforceable order. So those are just a handful of examples of what's happening with mediation in Saudi Arabia. I think that they're quite forward-thinking and at the leading edge of ADR in this region, and it's going to be interesting to see how it develops in future.
Thank you very much, Richard. In terms of ADR in general, usually whenever we discuss it, we really focus on arbitration without looking at the different tools that alternative dispute resolution mechanisms that provide for everyone. But I think with the introduction of the Singapore Convention and the ratification of it, in addition to Saudi leading by example for the region of the importance of mediation and going to Singapore and sign it at the time, I think that have set the tone in terms of the seriousness of adopting mediation as a viable option to parties. In addition, and this is something that I like to say always about mediation, it's always very interesting to me that mediation is a very integral part of the culture of the region, where we like to mediate disputes in a majlis or to the whoever is the highest authority in the community. However, there is a reluctance to take mediation in its official format, but I think that is with time is going to change and more success stories will happen. Thank you, Richard, for that overview. Paul, over to you. During the past 10 years, the legislative reform in the KSA have specifically, especially in the ADR field, have changed a lot. So how can you compare how the ADR field, how was it, how is it now, and possibly where do you think we're going with it?
Thank you very much, and it's a pleasure to be speaking to you today. When people ask me questions like this about arbitration in the Gulf region, which, believe it or not, does happen very occasionally, I have to start by humbly reminding people with my cut-glass BBC English accent about the historical period between the 1930s and the 1970s, where the Gulf states were on the receiving end of a number of arbitral awards which were regarded as, by the Gulf states, as unfair and on some occasions outrageous. There was at least one occasion where an English arbitrator issued an award that made a finding that he couldn't apply Abu Dhabi law because Abu Dhabi law did not exist, and that he would apply English law instead, this arbitrator being the brother of an English prime minister. And so I always approach these sort of questions with a degree of humility because things have changed quite radically in the meantime. But those kind of decisions have cast a long shadow over arbitration in the region, and that shadow is now finally starting to recede, and that's very, very good news. By the way, I should say that they weren't all British arbitrators. Some of them were Americans, like Tom. So the situation until 2012 in Saudi, I think, broadly reflected that suspicion of arbitration, international arbitration as a means of dispute resolution. And what we saw was, even though Saudi was a New York Convention country, in practice, the advice we had to give as international lawyers was that enforcement came with great risk, that in practice the Board of Grievances could and often did scrutinise the merits of the award and took a very close look also at the process. And this was despite the fact that, as I say, New York Convention country, but also they had an arbitration law in the 83 law did provide for a presumption of enforcement, but that presumption was often not applied. So the Board of Grievance effectively operating as a appellate body, and what that meant was that so when I started practicing here in 2002, I really did no Saudi arbitration work at all. And to give you an impression of how things have changed, last year, more than half of all the work I did had at least one Saudi aspect. It was either Saudi-related disputes or there was a Saudi party involved. And I think that is an indication of how the trend is moving for the international law firms and the seriousness in which we are treating the Saudi market. So how's that happened? Well, as you've heard over the last few sessions, the two major innovations, the 2012 arbitration law, which introduced an UNCITRAL-based arbitration law in Saudi, which also brought with it all of the principles that we as international arbitration lawyers are familiar with: party autonomy, competence, separability of the arbitration agreement, and so on and so forth. Freedom to appoint counsel, international counsel, also very helpful. But also the enforcement law of 2012, because, of course, ultimately the process is nothing if you can't enforce the award. And that established specialist enforcement courts with simple procedures. And I've had first-hand experience, of course, through local counsel, of using the enforcement process. And I found it to be astonishingly quick. Saudi's moved from being the most difficult enforcement jurisdiction in the Gulf to the quickest and most efficient, certainly in relation to my anecdotal experience. I had one enforcement action in which, within 2 weeks of issuing the proceedings, the commercial registry had been notified of the judgment, and all activity on the commercial registry had been frozen. So there could be no appointment or removal of directors and so forth. Really powerful tools. And then bank accounts were frozen and so forth. So super effective tool. Also boding very well for the future. And then, of course, we've got our hosts who have brought an element of expertise. I mean, my hope for your institution is that it serves a similar role to that which DIAC served when I first arrived here in the UAE, which was when the local courts saw that an award was issued within that institution, it was given a credibility that perhaps institutions further afield didn't have. And so we could advise our clients, look, if you're using this institution, you've got that much better opportunity to have your awards enforced. And I'm just conscious that I'm going over my 5 minutes, so I'll stop there for now.
Well, I would consider myself as a very either scary moderator because everybody's sticking to their time. So thank you very much. No, thank you very much for that overview. But if I can just ask you to elaborate a little bit more, if you have a crystal ball and you think where is the laws or legislations in Saudi Arabia going, very briefly, where do you think it is headed?
For me, the legislative infrastructure for the dispute resolution process on the arbitration side is already there. The issue is more one of application. It's the support that is evident from the judiciary, and all of the noises we're seeing there are very positive. The statistics that James published about challenges, and I think you said 6% success rate, which is perfectly good by international standards. The fact that only half of those seem to relate to the issue that most clients are concerned by, which is the uncertainty about the application of local law to any review or any review on the merits. I think it's about the educational initiatives that the SCCA is putting into place and having broad application. Well, one other thing, I think we need more and better published judgments. We need to be able to analyse the direction of travel by reference to what's actually happening on the ground. I think that's an important step.
And I think that topic of stats and data is clearly very much needed on, yes, local level in KSA, regional level, definitely, so we can compare it to the international statistics that are available. Absolutely, thank you very much. Moving on to Cameron, and the next question is for you. If we look regionally in the GCC states, can you give us an overall look into the changes and trends in the ADR rules?
I think we can all agree that over the last 4 years, there's been an unprecedented amount of change to the ADR landscape in the Gulf. And these changes have come in the form of new arbitration rules, new arbitration institutions, and a complete overhaul of some of the arbitration rules which have been in effect for a number of years. I think, in fact, if you think about any region globally, there really hasn't been that level of change anywhere else, and that really is fantastic to see. So what are some of these trends? Well, I think they focus on providing parties with greater flexibility to resolve their disputes, protecting the parties' freedom of choice, which is critical when it comes to ADR, and then finally also provisions to make arbitral process more time and cost efficient. I mean, if you take, for example, the UAE, Bahrain and Saudi Arabia, in the UAE, of course, in September of 2021, there was Royal Decree 24 of 21, which essentially made, the Dubai International Arbitration Centre Dubai's primary arbitration centre, although I'm sure the SCCA might have something to say about that now, given recent exciting developments. And of course, shortly after the decree in that same year, in 2022, DEAC updated their arbitration rules. And some of the key changes to those rules, which I think the community was excited to hear about, was that the DIFC is now the default seat of arbitration. Of course, that can be changed by parties' agreement, and indeed the tribunal has the power to choose a different seat as well. The rules also addressed third-party funding, which is something which a lot of the other international rules now do as well, so that was fantastic to see. And of course, they also included provisions around joinder and consolidation of claims. And if you look down the road in Abu Dhabi, the ADGM has put in place, has updated their arbitration regulations from 2015. And some of the relevant amendments to those regulations was that the parties don't need to have a nexus to the ADGM to actually have the ADGM as a seat, which is a fantastic development. And then it also encourages tribunals to adopt certain types of technology to assist with the effective resolution of arbitrations. Of course, in Abu Dhabi also have the ICC down there too with a representative office to assist with the administration of ICC arbitrations in the region and to promote the education of arbitration in the ADGM. And then most recently, Abu Dhabi has set up a task force made up of preeminent international arbitration practitioners as also regional practitioners, and importantly also the end users of arbitration to discuss the implementation and possible creation of another arbitration institution in the capital. If you turn to Bahrain, it too has recently, in 2017, introduced a new arbitration law. In that same year, updated its arbitration rules, and there's been a significant uptick in cases there. And then finally, if we turn to Saudi Arabia, I mean, today we've been hearing about the fantastic work the SCCA has been doing to promote the use of arbitration and the adoption of ADR in the kingdom. But I think it's also important to look at some of the recent legislative changes in Saudi which support and promote ADR. For example, in 2020, Saudi Arabia joined the United Nations Convention on International Settlement of Agreements Resulting from Mediation, the Singapore Convention. We've already heard about the importance of that and how significant that is for the region. In 2019, Saudi Arabia issued Royal Decree number 28004, encouraging all government entities and state-owned companies to settle their disputes with foreign investors via arbitration. Again, that's a significant law to be aware of. And then finally, in April 2020, the commercial franchise law came into effect in Saudi Arabia. And again, this piece of legislation gives parties the ability to settle disputes via arbitration and ADR. So, I mean, that's a quick canter through some of the changes we've seen in the Gulf recently. And as you can see, there's been a lot, all supported by the regional governments. And it's only going to result in ADR being chosen as the preferred route by international investors in particular to resolve their disputes throughout the region.
Thank you very much, Cameron. I think the key terminology which we heard Dr. Hamid use today is glocal, which is a very fascinating term, but very applicable as well when we see all of those changes, because we see that there is a lot of synergy in where those updates and trends are going, and they're all going towards best practices that are adopted internationally. Last but not least, the final question goes to Tom. What should parties consider in choosing a seat for an arbitration in the region?
Thank you, Fatima, and thank you for the question. I do like talking about the choice of seat because it is, in my view, if you take, for example, a complex construction project, the ratio of party and representative attention to importance is probably as large as with any clause in any contract. Unfortunately, many of our transactional colleagues don't really understand the importance of choice of seat and often don't consult with arbitration practitioners like those of us in the room when they do choose seats. And in that connection, my comments might be better delivered at Dubai Contract Negotiation Week rather than Dubai Arbitration Week, because I think most of the people in here will already know much of what I'm about to say. But unfortunately, there is not, so far as I know, a Dubai Contract Negotiation Week. And so my charge to all of us really is, when we leave the conference like this, to go to our friends and colleagues on the transactional side of the house and try to educate them a bit about the importance of paying attention to the choice of seat. Now, anyone who wants to learn about or teach their colleagues about the importance of the choice of seat, I commend to you the centenary, 2015 centenary principles of the Chartered Institute of Arbitration, which I have here, which set out 10 considerations that parties should take into account when they choose the seat. I don't want to speak of all 10. I want to focus briefly on 3. Firstly, the importance of a modern arbitral law. When you choose the seat, you're choosing the law that applies to the arbitration. That's axiomatic to arbitration lawyers, but not necessarily to others. You're not choosing the hotel in which the arbitration might be held, or the restaurants at which the arbitrators might be eating. We all know those considerations can be varied, but you are choosing the law that applies, and that's the key, first key consideration. Most of the Gulf states now tick that box with modern arbitral laws which are supportive of the choice of seat. You're secondly choosing the court that will supervise the arbitration. You're choosing the only court that has the ability to annul that award. Other courts can refuse to recognize it, but it's that supervisory court that can annul it. Obviously a very important consideration. You want to choose a seat in which you have trust that the courts are well educated as to, the judges are well educated as to arbitration and understand their role in arbitration, don't interfere too greatly in arbitration, but are also available to support it. And thirdly, and for our clients often most importantly, you're choosing the nationality of your arbitral award. You're effectively conferring on it the passport of the jurisdiction that you choose as the seat. We all know the importance of a strong passport. Thus, choosing the seat requires that one consider how the awards and judgments of the country you choose will be respected in other countries. Obviously, considerations such as whether the New York Convention applies, which of course in most countries now we see. Also, if you're in the region, think about the Riyadh Convention and whether or not the Riyadh Convention might provide an important basis on which to enforce an award outside of the seat. But finally, I noted earlier in some statistics that Christian had in his presentation, and if I understood those statistics correctly, what they showed was that in the last year, roughly 550 arbitral awards have been enforced in the Kingdom of Saudi Arabia. Of that 550, only 12 were foreign awards. If you choose the Kingdom as a seat, obviously your award is a domestic award there, doesn't even need a passport. If you're taking that award to you as a foreign party, a foreign investor or a foreign contractor, for example, for enforcement against a Saudi party, and you want to assure or at least increase the likelihood that the courts are going to enforce that award for you, consider whether a domestic award might be more familiar and more easily enforced than a foreign award. Obviously, that requires that you trust the independence of the court system with which you're dealing. But what we've seen in the last 2 years now at Dubai Arbitration Week from the SCCA presentation is that there's a great deal of effort in the kingdom now to educate the courts as to the importance of arbitration and the importance of arbitration to achieving Vision 2030. There is government support for that, and the institutions such as the SCCA are doing an excellent job with that. So I would charge all of us when we go and speak to our colleagues who are advising those who will become our clients when they have disputes to rethink and ask their clients to rethink or take a fresh look at the friendliness of jurisdictions in this region, in particular Saudi Arabia, as the choice of seat.
Thank you very much, Tom. It's a very good resource that you have referred to, which is the CIR London Centenarian Principles of how to choose the seat, and I urge everybody to take a look. Thank you for all the speakers, and thank you for sticking on time, because our main goal was to open the floor for questions if there is any. If there is any questions, please raise your hands. Going once, going twice. I think everybody's getting restless. They want a break. Okay, so with that, I thank all of our speakers for their comprehensive presentations. Please help me in giving them a round of applause.